Banking Regulation Act 1949. 1965 it was amended to cover the cooperative banks, bank licensing, restriction on loans and advances, rate of interest, cash reserve. All these things are discussed in detail under the Banking Regulation Act. Day-to-day banking depends upon the provisions of the Banking Regulation Act. And each and every banker is expected to have an idea about the contents and the meaning of the relevant provisions of the Banking Regulation Act to have effective functioning of a banker. Audit and inspection. Submission of balance sheets and accounts, control over management of banking companies, winding up procedures. Every bank is being audited by Reserve Bank of India. Reserve Bank has got all the powers to conduct audit. Recently also, without naming the bank, audit and inspection. Recently also, Reserve Bank of India has directed one of the banks to conduct a forensic audit. This is one of the latest developments in the banking industry. In addition, on account of certain developments, Reserve Bank of India has conducted scrutiny. This is part of audit from the angle of Reserve Bank of India. When Reserve Bank conducts audit, they would like to know whether the policy decisions given to the banks, policy directions provided to the banks are being followed in the interest of the general public and in the interest of the banking industry. And Reserve Bank of India will conduct wherever required the audit, and they have got the full powers to conduct audit for all the banks at any point of time without any intimation and information, so that they can have better access to know about what is happening in the banking industry and take appropriate decision. Submission of balance sheets and accounts, control over management of banking industries, as well as winding up procedure. When the bank is not able to function properly, effectively, and if it is felt by the Reserve Bank of India in the interest of the general public, the bank is unable to do business. In such cases, the winding up procedure will be initiated, and whatever the requirement of the law will be followed, inclusive of referring the matter to the central government wherever it is applicable. The Reserve Bank of India will also give moratorium of 6 months for the bank to come up to function effectively. In case if the bank is unable to come up and do their banking business to the satisfaction of Reserve Bank of India, then Reserve Bank of India will recommend to the central government for closing down the bank, and a winding up procedure will be completed as per law. Banking Regulation Act deals with regulation business of banking companies, control over the management of banking companies, suspension and winding up of banking companies, and penalties for violation of the provisions of the Act. Unless and until there are certain penalties are available, the effective functioning may not be assured. That is one of the reasons the penalties are being imposed whenever the bank are violating certain provisions of the Act, to see that the banks are functioning within the framework. Reserve Bank of India's whole capital is held by the central government. Central office is in Mumbai. They have got other offices in Mumbai, Kolkata, Delhi and Chennai, branches in most of the state capitals and other cities, to see that the proper functioning of banking is taking place and access to Reserve Bank requirements are taken care of. Governor, not more than 4 deputy governors appointed by the central government. Reserve Bank of India is headed by the governor, and there are 4 deputy governors appointed by the central government. Other directors in the Reserve Bank board are nominated by the central government. In such cases, people from different walks of life, from the different industries, to support and to understand the requirements of the general public as well as the industry requirements are given importance. That is the reason when directors are appointed or nominated by central government, they take into account these aspects as well. Central board, local boards are at Delhi, Mumbai, Kolkata and Chennai. The deputy governors, executive director and other officers are ensuring that the Reserve Bank functions are taken care of. Section 22 of the RBI Act provides sole authority for Reserve Bank of India to issue and manage currency in India. Denomination from 2 rupees to 10,000 rupees, Reserve Bank has got the powers to issue currency notes. As of today, the maximum currency note denomination wise is 1000 and the minimum currency note denomination wise is 2 rupees. There are various currency notes are available. All these currency notes are supposed to be legal tender, then only that can be circulated within the country and utilized. Decision by central government, recommendations by central board, legal tender. Legal tender is very, very important. Whenever Reserve Bank brings out a new rupee note, they will invariably mention in the papers the existing rupee notes are continued to be legal tender. That is the reason when an individual is able to go and give that particular currency, he can get in exchange something in return for the value which it holds. And Reserve Bank of India governor signs and he gives a promise on behalf of the central government that the value relating to the particular note will be exchanged by Reserve Bank of India. That is applicable from 2 rupee note to 10,000 rupee note, whereas 1 rupee note is not printed, issued by Reserve Bank of India. It is treated as a coin. It is being minted or printed. Coins are minted and rupee note is printed by Government of India but managed by Reserve Bank of India. The role of the bank as regulator of banking sector is mainly by virtue of the provisions of the Banking Regulation Act 1949. RBI is primarily regulator on banks. However, the central government also has extensive powers under both RBI Act and Banking Regulation Act, either directly or indirectly over the banks. Generally, the central government will not interfere in the functions of Reserve Bank of India. The credibility of Reserve Bank of India is important, and that is the reason Reserve Bank of India is the supreme bank to take decision, implement the decision, and it is being supported by the central government. Otherwise, the credibility will be affected. The banking industry will not be in a position to function effectively. In public interest and in consultation with the governor, the central government can give directions, appeal to be made to central government on removal of managerial personnel, cancellation of banking license, refusal of certificate regarding floating charge of assets. We will discuss what is floating charge at the appropriate level, and wherever certain decision to be taken, then central government has to be taken into confidence, and central government is having the supreme authority to take and effect the decision. Ways and mean advances are provided by nationalized bank, public sector bank, regional rural bank, Reserve Bank of India. This is yet another question. The answer is Reserve Bank of India. Ways and means advances means it is a temporary finance which is made available to the state government and central government when the central government and the state government are not having funds to meet their obligations on a day-to-day basis. In such cases, Reserve Bank of India gives a temporary finance around 15 days to tide over the monetary condition or monetary shortage as the case may be. Identify the power not pertaining to Reserve Bank of India, yet another question. Power to license, power regarding audit of banks, power to impose penalties, none of these. And all the three are associated with Reserve Bank of India. So the answer is none of the above or none of these. Government has the powers to suspend the operations of the Banking Regulation Act, to notify other forms of business which a bank may undertake, appointment of court liquidator, suspension of business and amalgamation of banks. Liquidator is a person who is being appointed generally by the court to look after the liquidated company's assets, take over the assets and dispose of the liabilities. In the case of banking industry, Reserve Bank of India can be a liquidator, or Reserve Bank can appoint either the State Bank of India or any of the nationalized bank as the liquidator for any of the banks which is under liquidation. So that particular liquidator will play the role of a liquidator to settle the issue relating to the liquidation of the particular bank. A cooperative bank is a cooperative society engaged in the banking business. A primary cooperative bank, a district central cooperative bank, a state cooperative bank. These are the types of cooperative banks available. Basically, India is predominantly a rural based sector, the number of persons who are all more in the rural area, they require the banking support. In such cases, the nationalized banks as well as the public sector banks alone are not enough to cater to the needs of the banking industry. That is the reason cooperative banks have been set up and they are all functioning to help the rural sector mainly. Registered under the State Cooperative Societies Act, cooperative laws of the state, formation of banks, management and control over personnel. These are the things which are associated with the cooperative banks. Register of cooperative societies use wider powers on cooperative societies from registration to winding up. In the case of banking, Reserve Bank of India has all the powers like that. As far as the cooperative societies are concerned, registrar is having the supreme authority to take care of the requirements of the cooperative societies, which includes the banks wherever the bank is functioning as a cooperative bank. That includes right from the registration of the cooperative unit till it is being wound up. If a cooperative bank is operating, functioning in more than one state, it is called Multi-State Cooperative Societies Act applicable, and it is called Multi-State Cooperative Bank. Registrar appointed by the central government. Otherwise, if only one state the cooperative bank is functioning, it is called the State Cooperative Bank, and it is the registrar is appointed by the concerned state government. Cooperative bank come under the regulatory purview of the Reserve Bank of India. Since it is a bank, related to the banking, Reserve Bank of India is having the supreme authority. Section 56 of the Banking Regulation Act is applicable, which is effective from 1965 onwards. Licensing and regulation of banking business rests with Reserve Bank of India. In fact, cooperative banks are having two masters. One is Reserve Bank of India related to banking. The other one is registrar relating to cooperative societies requirements. Cooperative banks come under dual control. Just now I explained to you. Cooperative banks registered with the Deposit Insurance and Credit Guarantee Corporation Act, RBI has the power to order their winding up. Deposit Insurance and Credit Guarantee Corporation is an organization which supports the banks as far as the protection of deposits and loans are concerned. Mainly deposits. If a person is having a cooperative bank deposit and up to 1 lakh of rupees, cooperative banks registered with the Deposit Insurance and Credit Guarantee Corporation Act, RBI has the power to order their winding up. Credit Guarantee Corporation, Deposit Insurance and Credit Guarantee Corporation is an organization which supports the banks wherever the banks are facing problem of winding up. In such cases, the depositors who have parked the money with such bank can be getting certain amount from the DICGC, which is popularly known as DICGC. In respect of cooperative banks, one can observe in the fixed deposit receipt, they print generally up to 1 lakh rupee, it is covered under DICG's coverage. That means if the particular bank is having a registration with the particular DICGC and they have been paying the regular premium, in case the particular cooperative bank winds up and the depositor is unable to get the full amount, up to a maximum of 1 lakh per depositor from a bank, he will be able to get it. This is the support which is available. In such cases, when it is registered, Reserve Bank has the power to order for winding up. Cooperative banks come under the control of Reserve Bank of India by virtue of certain provisions of Reserve Bank of India Act, Banking Laws Application to Cooperative Societies Act 1965, Banking Regulation Act, all the above. B is the appropriate answer according to Banking Laws Application to Cooperative Society Act 1965. Cooperative banks are come under the control and power of Reserve Bank of India. In respect of terms and conditions of services of its workmen, opening and closing of its branch premises, a bank is answerable to its corporate office, Reserve Bank of India, labor authorities, its head office. The appropriate answer is C, labor authorities. KRD, a cooperative bank, has secured permission to have branches in other states as well, and the appropriate answer is multi-state cooperative bank. In such type of questions, there can be repetition of certain words. The candidate should not be carried away by seeing only the first word. You will have to go through all the four, understand the question, relate the answer, accordingly you will have to answer. He or she has to answer. There is a cooperative bank facing winding up. The said cooperative bank is registered under the Deposit Insurance and Credit Guarantee Corporation Act. Just now we have discussed. Then who has the power to order its winding up? Reserve Bank of India, state government, Register of Cooperatives, none of them. The answer is Reserve Bank of India, because it is registered under the Deposit Insurance and Credit Guarantee Corporation Act. Of late, banks are involved in selling other than banking products such as mutual fund products, insurance products, and also associated in collection of money, accepting share application forms and others. Banks are now concerned about increasing their income, reducing their expenditure. In the ordinary course of business, when they are able to extend the banking services, when there are opportunities available for them to earn better, they are all welcome. This is called cross-selling. By having the cross-selling aspect, the bankers are able to increase their income flow. That is the reason one can find nowadays almost all the banks are associated in doing other than banking services as well. Besides banks, others also accept deposits from public. They are all called non-banking companies. There are companies, even companies are also accepting deposits from the public. Other unincorporated associations of persons and individuals are also accepting deposits. Reserve Bank of India regulates acceptance of deposits by NBFC, and non-banking financial companies acceptance of public deposits. Reserve Bank Directions 1988 is applicable. Other direction issued by it under the appropriate chapter of the Act is also applicable. As far as the acceptance of deposits are concerned, major deposits are accepted by the banks. Other than banks, the NBFCs, other companies also accept public deposits. In such cases, they are all coming under the directions and the guidance of Reserve Bank of India. They are supposed to follow those things. Other companies are regulated by the central government under the Companies Acceptance of Deposit Rules 1975, Section 58A of the Companies Act 1956. Though Reserve Bank of India is having all the authority, wherever required, other than Reserve Bank of India, central government can also give directions to protect the interests of the general public. As per Section 6 of the Banking Regulation Act, banks may undertake certain non-banking business in addition to the business of banking. Such banks may be subject to the regulatory control of other agencies as well. Dealings in securities like shares, debentures, SEBI, insurance business IRDA, mutual funds, Reserve Bank of India, SEBI, these are all the controlling agencies who give direction and have a control on all the functioning related to these issues. The candidates are required to have some sort of test. At random, I will try to explain some of the answers. Let us take this question. A private sector bank has accepted the deposit receipt of another bank under safe custody article. Considered to be a secondary business of a commercial bank. True. Customer service. False. In fact, it is a primary service or primary business. As we have seen earlier, the primary or the main function of a banker is to accept deposit, lend money and invest money. Other than that, all are called secondary business. Though the answer true is appropriate, the more appropriate answer is required. So, true, customer service, false, in fact it is the primary business. Here, the primary business is given. Had it been given the secondary business, the answer would have been D. Now that the answer is, it is called a secondary business, true is the appropriate answer. Identify which one is not the asset of a commercial bank. Recurring deposit, home loan which is under NPA, that means non-performing asset, both A and B, none of these. The candidate has to understand what is the question and then he will or she will have to identify the answer. It is related to not the asset. That means this refers to the deposit. So, the answer here is identify which one is not the asset of a commercial bank. B is the asset. All the loans and advances are called assets of the bank. All the deposits are called liabilities of the bank. Here it is asked which is not the asset of a bank. Had it been asked which is the asset of the bank, B would have been the answer. The answer here is relating to deposit. The answer is recurring deposit. A is the answer. Reserve Bank of India provides these temporary advances to meet immediate needs of the central and state governments when there is interval between expenditure and flow of revenue. Fit and final, ways and means, bridge finance, temporary credit facility. The answer is ways and means. Fit and final is related to or associated with corporate governance. Bankers are also part of corporate governance nowadays. Bridge finance is a temporary finance which is generally given for other than the central government, state government, that is called bridge finance. Temporary credit facility is made available to the clients and the borrowers of the banks wherever it is required and whenever it is desired. So the answer is B, ways and means advances, which is being extended by Reserve Bank of India to the state government and central government as the case may be. A bank is compelled to acquire an immovable property originally taken as security. The loan account has become NPA, non-performing asset, and the same has been purchased for throwaway price. The same would appear in the bank's balance sheet as a liability, an asset, non-performing asset, none of these. The answer is none of these. The correct answer is non-banking asset, which earlier we have discussed.